Okay, so we have a question that reads, my will currently leaves everything to my spouse. Will a durable power of attorney protect my assets to be used for my benefit only as long as I am alive? Each one of us has our own net worth, and it's a later in life marriage. So the first thing that we need to think about to answer this question is, what is the purpose of a will and what is the purpose of a power of attorney? So the purpose of a will is to designate how probate assets will be passed at the time of your death. So my will currently leaves everything to my spouse. Perfect. Now, the purpose of a power of attorney is to give someone else the authority to act on your behalf. So the question, will a durable power of attorney protect my assets to be used for my benefit as long as I'm alive? So we have to think about this in terms of, what does a power of attorney do? Who is named as the attorney in fact to carry out the powers of the power of attorney? What specific powers are they given? So in general, a power of attorney should only be used for the benefit of the person who signs it. There are situations we've come across where these are misused, so it's important to find somebody that you really, really trust, who would never even think about doing something that wasn't in your best interest. Now the question is, will it protect my assets? And the answer to that is no. So it will protect your assets as far as someone else using them. That should always be for your benefit under a power of attorney. However, a power of attorney is not going to protect you from, let's say you get divorced, or if you get divorced, it's not going to protect your assets from being considered marital property. The only way to really do that is through a validly signed, executed, considered prenuptial agreement that is carried out. So there are likely things you have to do after you sign the prenup. For the purpose of protecting your assets, the one thing that, and especially because this person indicates that it's a later in life marriage, one thing that we are frequently looking at is TenCare or Medicaid, as it's known nationally. In Tennessee, it's called TenCare. And TenCare does not look at which assets belong to which spouse. If one spouse needs TenCare, the TenCare staff is going to be looking at, and you're going to have to disclose assets owned by both of you. And then there's a formula for how much you can keep. But if you are married, you need to consider that for TenCare purposes, they will consider everything owned by both spouses. So the answer to this is, I don't think you're accomplishing what you're trying to accomplish. Unfortunately for TenCare with married people, there's not a good way to preserve the assets of one's spouse without a lot of advanced planning. It can be done, but again, you need to be planning for that ahead of time. And that is it. So it's great that your will leaves everything to your spouse. Your spouse is probably who you want to benefit anyway, but should something unexpected occur, such as long-term illness that requires skilled nursing care, or a divorce, the power of attorney is not going to protect you in those circumstances or protect your assets. If you have a question, we're happy to review it and answer it. I will pop a link to the questionnaire submission, the question submission, below.